Hello, beautiful people. Mic check, mic check. Slap that like button. Slap it like you like it. Good morning. Good morning from a slightly muggy 56-degree Seattle. Good to see you all. Slap that like button. Shout out to the best mod squad on the internet in here doing the damn thing. Appreciate you. Appreciate you. Shout out to everybody who's watching. Shout out to all the subscribers here on YouTube. Shout out to all the members on Patreon and YouTube. Shout out to all the supporters on Substack. Shout out to everybody who has purchased your copy of Bloodlines and Battle Rhymes. Well, it's morning. I have morning eyes, but I'm here. I'm here. Got an update on the docket probably like 2 hours after yesterday's live, and I strongly considered doing another live, but honestly, I just could not will myself back to it. So here we are this morning. Smack that like button like it's the ops. That's a good one. I like that. That's a good one. Breaking news. Oh. You know, I wasn't gonna say anything because I didn't want people to think that I was being a negative Nancy towards this brother, but, um, I looked up the attorney representing the man who has filed a lawsuit against Fat Joe, because I noticed that the attorney was just one man on behalf of his own law firm in his name. And that means you either have a very robust practice or, a very robust firm with a very robust practice. Or so anyway, he was arrested this morning for running over the process server. Tyrone Blackburn Jr., I do believe, the attorney representing Fat Joe's former hype man in a $20 million civil case, was reportedly taken into custody Wednesday morning. That's today. Today's Wednesday. Today's Wednesday. I know today's Wednesday because my meeting started at 7, which means I had to turn on an alarm because I stayed up way past my bedtime. Way past my bedtime. I used that alarm. I woke up still at 5:30, but I was like, "Child, Imma feed these cats, go right back to sleep, turn on this alarm, wake me up at 6:45." Anyway. Tyrone Blackburn, the attorney representing Fat Joe's former hype man in a $20 million civil lawsuit, was reportedly taken into custody Wednesday morning in connection with allegedly hitting a process server with his car. As previously reported, Terrence Dixon's lawsuit against Joe was preceded by the Terror Squad Entertainment founder, accusing him of extortion and defamation in a prior lawsuit. Blackburn was also named. So he sued Terrence Dixon, and he also sued this lawyer. Blackburn has been arrested for assault. The accusation stems from an alleged incident in May of this year in which Blackburn is said to have caused a process server minor injury after hitting him with his vehicle. Joe's legal team argues this was done intentionally to avoid being served with Joe's lawsuit. Jesus, Devonte Christ. my heating pad. Feeling old this morning. Feeling old and cold. So, uh, Fat Joe is being represented by Joe Tacopina, who is a bulldog. Tyrone Blackburn's arrest comes as no surprise to me. It's just the latest example of his malicious and manipulative pattern of misconduct finally coming to light. Joe Tacopina, Fat Joe's lawyer, said in a statement shared Wednesday. Blackburn is an embarrassment to the legal profession, sorry, and it's a disgrace watching him use the court system to shield his extortion tactics. Tacopina continued, this is exactly why Mr. Car- Cartagena, proactively sued Blackburn and his client Terrence Dixon in April because he knew they intended to try to destroy his reputation by peddling salacious lies. Today's arrest is just the first step, but I'm confident that my client's name will be cleared from all those falsehoods and Blackburn be brought to justice once and for all. I think you're going to need a new lawyer, bro. Tacopina was one of ASAP Rocky's lawyers. Yes, he was. Yes, he was. He gets around. He's a bulldog. He's a bulldog. He's a bulldog. I don't particularly like him as a person. Let me just be real clear. I don't like him as a person, but he is a bulldog of a lawyer. Won't take anything away from him on that at all. Shout out to everybody who's watching. Hello, welcome. Hit the like button. Thank you. Thank you. Take your shoes off, take a seat, get a snack, tea, coffee, all the things. Got croissant, cinnamon roll. So yes, we did briefly discuss the fact that uh Fat Joe's ex hype man is suing him for $20 million, alleging intimate types of assault. I think that's the safest way to say it. Nope, hit him with his car. Hit him with his car, got into his car as the process server, which apparently was an older gentleman. Um, got into his car as the process server was attempting to serve him and, aggressively drove away without any regard for the fact that there was a person there and did allegedly hit him with his car and did allegedly cause, minor injuries to the body that could be observed. An old man. Yes, an old man. Mhm. Yes, he done hit an old man. Yeah, gonna make me pull up TMZ. TMZ is such trash. This is the attorney in question. Booked for assault. The process server is 66 years old. That is a 5 head if ever I have seen one. My Jesus. My Jesus. My Jesus. That hairline starts behind his ear and just goes straight up and over to the other side. I looked him up when the lawsuit dropped. I said, "Oh, I don't have a good feeling about this one. I don't think this is gonna go well." But hitting somebody allegedly with the vehicle, I did not have that, but yeah, in my cards at all. But yes, cops say it all started on the night of May 12 when Blackburn got into his vehicle as a 66-year-old messenger was serving him a complaint in the Fat Joe case. Blackburn allegedly slammed his car into reverse and backed up. Oh shit, hitting the process server in the leg and causing a minor injury. The victim reported the incident to police. Now, that sounds real bad. That sounds bad, sir. Sounds bad. Those sunglasses are really bothering me. They really, really bother me. They're too small for his face. Yeah, I don't know if the lawsuit is legit or not, but yeah, I have my opinions. This is not helpful. It's not helpful. Not Jimmy Neutron. Not Jimmy Neutron. I love that movie, by the way. I love Jimmy Neutron. I think Jimmy Neutron is so underrated. I've seen that movie at least 100 times because it was one of my son's favorites when he was in the hospital. I still have Jimmy Neutron. Sure do. That movie is hilarious. Oh my god. Forehead needs a real estate lawyer. A 6 head. That big ass forehead, and he couldn't figure something out. Was he born in a windstorm? Hairline blown way the hell back. Oh my god. Oh my god. You could map how he was driving over him on his forehead. Oh my god. Oh my god. That's some GTA shit. It really is some GTA shit. Just get in the car and just run over, dude. That is some GTA shit. And he does look a little generation GTA to me. Ooh, ooh. Rachel Cunty, the devil has his hairline. Oh, 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 oh. Yeah, the shadow is not his beard. Thank God. I would be on the floor. I would not have been able to recover. Oh my gosh, Coach Tut. Thank you for kicking off the goal today. Mojo Head from the Powerpuff Girls. Mojo Jojo. Oh, uh, I don't know what I was thinking putting this man's picture up here. I don't know what I was thinking. I should have known. I should have known. She always gonna go in. Yes, this fool right here, this fool right here allegedly hit a 66-year-old man. Oh my God. D2B2. Broski got lined up with a protractor. If that was a beard, I would be on the floor. I would literally, I would have to walk away. I would definitely, I'm trying not to cry now because y'all are killing me. Oh, a protractor is thick. It's thick. Oh God. It's always the nerds, man. The nerds have the thickest burns. The nerds have the thickest burns. Oh, I gotta put it back up there. Broski got lined up with a protractor. Oh. Marshall Irons, damn. Everybody chew broken glass for breakfast? You woke up nasty. Listen, 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 listen. Let us have the little joys we can have. Do not besmirch Pinky in the brain. No, do not besmirch Pinky in the brain. Oh, protractor is incredible. Incredible. Oh, he should call somebody for a man unit. He's definitely a candidate. Definitely a candidate. Definitely a candidate. That's an endorsement for your ass. Oh, God. That line belongs in a book. It does. Okay, okay, thank you. Okay, yes. We need some levity. We really do. D2B2. I can't believe that someone would walk out of their house with their hairline that far pushed back. It's time to let it go. I mean, it's a nice suit, but given the situation, it's kind of central casting. Jesus, it's a big forehead. He otherwise looks like he has very nice hair. But definitely front unit eligible. Definitely front unit eligible. Because it makes this down here look very disproportionate. In this installment of Souls Unhappy with Their Bodies. Oh my God. Nady, all right, I'm gonna have to replay again because y'all too entertaining to be background at work. You are not the only person who has lodged this complaint. Try to listen quietly at work, just in your earbuds, minding your own business. Nobody else around you the wiser, but we got you damn near suffocating yourself trying to not laugh out loud. Gosh, X. Who is that? Oh, let's just read it. More drama in the Fat Joe civil case. His accuser's attorney, that would be this man right here, Tyrone Blackburn, just got arrested for allegedly mowing down a process server with his car in New York City. Yes, he did. A rep for the New York Police Department tells us Blackburn was taken into custody Wednesday morning and booked for assault. Cops say it all started on the night of May 12 when Blackburn got into his vehicle as a 66-year-old messenger was serving him a complaint in the Fat Joe case. Blackburn allegedly slammed his car into reverse and backed up, hitting the process server in the leg, causing a minor injury. The victim reported the incident to police. Fat Joe's lawyer was like, yeah, He's a pathetic excuse for an attorney. And then the chat saw this. And just, oh my God, let it rip. You could use that forehead for a charcuterie board. Oh. Definitely front unit eligible. Definitely. Yes, it's not a flattering picture in any way, shape, or form, unfortunately. From the top to the bottom, it's not good. The glasses, wrong. This protractor drawing situation, bad. Backpack, I'ma say no. I'ma say no to the backpack. It's a backpack lawyer. Imma say no to that in that suit. There are backpack lawyers. There are backpack lawyers, and I'm not shading backpack lawyers. But you trying to act like you not one, and you is one. Well, TMZ is good for that. They good for taking the most, awkward screenshot they possibly fucking can. Oh my God, he needs a Go Fringe Me account. Where do you people come up with this? Where do you come up with these things? I'm jealous per as usual. This is the lawyer representing the dude who just sued Fat Joe for $20 million. He just got arrested today because he allegedly hit a 66-year-old process server with his car in May when Fat Joe was serving him, because Fat Joe had already sued him and his client for extortion and something else. And they came back with this 20 million. So when they were doing service, he hit an old man with his car. Allegedly. I looked him up, and the chat has been going off for 15 minutes. This isn't even the topic. This was just breaking news. It literally I just saw it. I saw it. This is what was in my timeline, but yes. TMZ has the photo of the lawyer. So Go Fringe Me account. True depiction of a biscuit head. This is true. There's a lot of space for graphics. There's a lot of space for graphics. Lots to work with. Oh my God, I'm dead. I'm so dead. I'm so dead. Y'all can't hear it. My soul is screaming. Nubia Gross pulled a Suge Knight. Oh my God. Okay, well, ooh, well, this was a good little cackle session. Ooh, this was a delight. Y'all get them off? Y'all good? Safe space. We listen and we don't judge. Make sure you got it all out your system now. Yeah, yeah, little mid-morning clown session. Whew. Jesus. Jesus. Okay, I've been waiting for this day. Let's get to, why it is that we have gathered here today because I've been waiting for this day. There are several days related to this situation that I'm waiting for, but I've been waiting for this one. I've been waiting for this one. Okay, the docket. Okay, let's back up. The Barry White estate sued Rodney O and Joe Cooley for copyright infringement over Everlasting Base a couple months ago. Shenanigans ensued very quickly in that. Enter Necole Key, business associate of Rodney O, and the person who was negotiating the usage of Everlasting Base in Future and Metro Boomins like that with Kendrick Lamar. Shenanigans on this docket all day, every day. Okay. Because Miss Key interjected herself onto the docket in unprecedented and, in my opinion, unhinged fashion, Rodney O and Joe Cooley lost their lawyers. Now, they say they lost their lawyers for other reasons, but that's not what the lawyers cite when they withdrew. And the judge said, yes, you can go. So Rodney O and Joe Cooley are representing themselves. They're pro se. That's what that means. After being rebuked firmly by the judge as plain lawyer, trying to take the place of their attorneys and litigate this case, Necole Key remains engaged as, consultant, advisor, whatever you want to call her. Super self-important. Okay? Super self-important queen. They have just been filing the most nonsensical things on the docket in this lawsuit. Again, the Barry White estate suing, or the Barry White Trust suing Rodney O and Joe Cooley. Then Rodney O and Necole Key decided that they would sue everybody associated with like that in a separate action. And that went through a process of judicial review with the chief judge of the Southern District of New York. And that case was referred back to the judge who is overseeing the original lawsuit. And nothing has happened on that lawsuit because Necole Key and Rodney O have not served. The court has issued summons, but none of them have been returned, insofar as I can tell. So they haven't served Kendrick, they haven't served Future, they haven't served Sony, and the 11 other people that they're suing this lawsuit. So nothing has happened on that. But on the original lawsuit, the docket continues to be filled with a bunch of bullshit. And I've just been watching it and not wasting your time with every single nonsensical tit for tat. Because as I've been observing this Judge Coate, she seems to let things kind of stack up on the docket, and then she issues a document that has multiple orders inside of it. And so I've just been waiting. I've been waiting for things to stack up and for her to bowl a strike. Basically. Basically. So, when I tell you that 1,000 things have been, added to this docket, you're just gonna have to trust me on that, because we are definitely not gonna go over all of them because they are nonsensical filings and improper in several ways, and I don't wanna confuse you or me or waste our time going through every single one. Excuse me, sorry, but there are 2 that we're gonna look at, and then we're gonna look at the order that came down yesterday after, of course, after I got off of, um, the live. So, the first thing that we're gonna look at is a letter from the Barry White Trust in response to one of Rodney O's weird ass filings, okay? One of the very weird things that Rodney O is trying to do right now is he's going back through his docket for some reason. Apparently, this is part of some strategy they have. I have yet to figure out what it is. But he's gone back through the docket on this original lawsuit, and he wants the court to strike some things that his side entered onto the record. For some reason, I don't know why, but for some reason, maybe I'm starting to form an opinion as to why. We'll start with for some reason. He's trying to go back and strike any reference of like that in this original Barry White v. Rodney O. Joe Cooley lawsuit. They're the ones that introduced it. Okay. So, and this is on top of, like I said, they're just do this, do that on the docket all the time, right? To the parties, to the judge, do this, do that. And the judge has just been crickets. So, this is the trust opposing some of the things that he's been trying to do on the docket. And I'm just gonna skip to the good part, okay? This lawsuit has only become a quagmire created solely by defendants filing numerous frivolous motions or motions filed for the purpose of creating a record of unfounded vitriolic attacks against counsel and the plaintiffs. The defendant's own attorney advised his client. It is my opinion that it is not likely Rodney would be able to prevail in this litigation given the evidence that has been presented and the overwhelming case law and precedents that is not in our favor. Uh, and then she references a document on the docket. While defendants may disagree with the allegations, which they have every right to do, they do not have the right to undertake a campaign of filing frivolous motions, pleadings, and trying the case in the press on fabricated facts. Necole Key, Oliver's belatedly putative partner on the first infringing work, has disseminated unfounded ad hominem attacks on counsel and their family and created news alerts. And then they cite them. Plaintiffs respectfully request that, as set forth herein, the court put the defendants on notice that their conduct has legal repercussions. Defendant Oliver claims that a document should be stricken as fraud. plaintiff has falsely represented that I or someone on my behalf executed a licensing agreement with Eric Weissman Licensing Inc. regarding the Barry White composition. I affirm that I have never seen, signed, or authorized such an agreement. It is this exact same document that Mr. Oliver verified in Oliver et al. Barry White Family Trust. To the extent that Everlasting Base infringes on I'm Gonna Love You Just a Little More, Babe, and the amended complaint, the indemnification provision, blah, blah, blah. Okay. While Mr. Oliver asserts all manner of damages to his financial success, as late as May 1, 2025, he was negotiating to receive over $400,000 from Sony, known only through documents that defendants themselves produced. And she also responds to a bunch of stuff that Joe Cooley has put on the docket that has been just been a bunch of nonsense. While it is well established that the submissions of pro se litigant must be construed liberally in an effort to protect the party in light of their lack of legal training, a party's pro se status does not exempt a party from compliance with relevant rules of procedural and substantive law. Defendants' current motions, similar to various other motions they have filed, require unnecessary oppositions, letters, and other filings despite making requests for which no possible relief may be granted. Further, pro se filings do not serve as an impenetrable shield, for one acting pro se has no license to harass others, clog the judicial machinery with meritless litigation, and abuse already overloaded dockets. They took off a glove and they've started slapping. The defendant's constant filings have overloaded this docket and turned an otherwise straightforward copyright infringement claim into an endless barrage of motions which have no bearing on the merits of the case. A court can order a pro se litigant to pay legal fees. However, the court must adequately warn the pro se litigant before imposing such an order. In addition, lack of meritorious claims alone does not warrant sanctions, especially if a plaintiff is proceeding pro se. While a pro se litigant's papers must be construed liberally to raise the strongest argument they suggest, pro se status does not exempt a party from compliance with relevant rules of procedural and substantive law. That's repetitive. The defendants' continued ad hominem attacks and the filing of frivolous motions to support their fabricated public relations narrative need to end. While legal proceedings are indeed complicated, pro se parties are still bound by the federal rules of civil procedure. Plaintiffs, that's the Barry White Trust, have incurred unnecessary legal fees based on defendants' filing of meritless motions and ask the court to put defendants on notice that unless such conduct stops, they will risk sanctions, including the costs and fees incurred by plaintiffs' opposition to their frivolous motions. So that was on the 16th. The Rodney O still filing shit, right? Then he demands a conference. So here's another letter. This is from 2 days ago from the lawyers for the trust. Dear Judge Coate, we are the attorneys for the plaintiffs in the above captioned action. We write in connection with the letter motion to the court filed by defendant Rodney Oliver, which is premature and inaccurate. While we believe that ultimately the parties will need a conference, we believe that such a conference is premature. The court ordered document production to commence on June 13. Pursuant to the court's order, plaintiffs provided written responses and also provided an initial tranche of documents withholding confidential documents until Necole Key signed the confidentiality order. Plaintiffs also advised Mr. Oliver that it was a rolling production. That means ongoing. On June 14, Mr. Oliver notified plaintiffs that we had 10 days to respond to his letter, attached as Exhibit B, before the end of his own unilaterally imposed deadline. Mr. Oliver filed his letter with the court. We have responded to Mr. Oliver's letter and attach a copy of that as Exhibit C. As set forth in our June 23 letter to Mr. Oliver, plaintiffs have provided materials which he claims he did not receive and provided him with the Bates numbers of those documents, where they're being stored online and how to access them is what they're talking about. So we've looked at in Drake v. UMG document storage, right? During discovery, this is what she's referring to. So we've put these documents where they are. They've been tagged with what's called Bates numbers. Those are reference numbers. We've provided them the Bates numbers. That's what this letter is saying. Rodney Oliver keeps filing all this shit, my words, of they're not producing this, they're not producing that. And he's been doing that forever. But now that, discovery is actually happening, document production is actually happening, he is still filing shit saying they're not giving it to me. And he's coming up with his own arbitrary deadlines of give it to me by this point in time or blah, blah, blah. And they're saying, Your Honor, we've done this and we have proof that we've done it. And it gets worse. Okay. So we have provided materials which he claims he did not receive and provided him with the Bates numbers of those documents. We have redacted confidential chain of title documents that are ready to produce, but have advised Mr. Oliver that we will not produce them until Ms. Key, his partner, signs the so-ordered confidentiality agreement. Notwithstanding our request on May 28, June 13, June 16, and today, Mr. Oliver has failed and refused to provide Ms. Key's signed confidentiality agreement. While Mr. Oliver wrote to the court and stated that Ms. Key is currently unavailable due to serious health concerns, y'all, hold on to something. Ms. Key was active on social media in connection with this case, posting as recent as June 12, 2025. More importantly, the Ignite feature on the document production shows that there were 2 people who accessed the documents that they are telling the court they don't have. One of the recipients who accessed the files shows an IP address located just 1 block away from Miss Key's address. Mr. Oliver has not identified the 2 people who accessed the document production. They took off the other glove. They're irritated, pissed off, and they've had it. They're on some, oh, really type shit. When I read this yesterday, I was like, good Lord, if I could get off this couch and have a live. But I just couldn't do it. I just couldn't do it. Y'all, I left that live and went and had macaroni and cheese and that bison from that food that my son brought me. That's the best bison I've ever had in my life. Number 1. And number 2, I had macaroni and cheese and bison and rolls, fresh rolls. You expected me to come back to a live? I looked like I had good sex. After that meal, I was like, pour me a bourbon. The day is done. But I read IP address located just a block away from Miss Key's address. They said, oh, what do you mean you don't have access to the document? While Mr. Oliver wrote to the court and stated that Ms. Key is currently unavailable due to serious health concerns, Ms. Key was active on social media in connection with this case, posting as recent as June 12th. But more importantly, The Ignite feature on the document production shows there were two people who accessed the documents. One of the recipients who accessed the file shows an IP address located just a block away from Miss Key's address. Mr. Oliver has not identified the two people who accessed the document production. Finally, in our June 23, 2025 letter, we asked Mr. Oliver for times to meet and confer. This is a technical term, meet and confer, and also asked that a court reporter transcribe the meet and confer. As the court is aware from Mr. Oliver's multiple filings, counsel is apprehensive of having a call without a transcription. And that was the other thing that I noticed in one of their other letters is while Rodney Oliver is quoting what opposition counsel says, opposition counsel has started quoting transcripts. Actually, Your Honor, what was said was. So they're done playing with these people. They're done. So we asked for a meet and confer. We asked, to have a court reporter transcribe the meet and confer. To date, plaintiffs have received no documents from defendants at all, which would also be the subject of a meet and confer and a potential discovery issue. We ask that a conference be scheduled in 2 weeks in order for plaintiffs' production to be completed and for defendants to produce their documents. So this is, again, a letter to the judge saying discovery is not done because Rodney Oliver demanded a conference. I want this, I want that. They're not giving me this, they're not giving them that. So this is a letter saying conference is premature. Let's do it after this, portion of discovery concludes to see if it's even necessary, because we should be meeting on our own. He should be giving us dates. And also, we've given them documents and they appear to have accessed them with no problem. Yes, we have confidential documents that we are ready to produce. We're not producing a fucking thing that we have marked as confidential until Necole Key signs the confidentiality agreement. We've asked 4 times. They've said no. Their excuse is she is gravely unavailable. Well, if she's gravely unavailable, who with an IP address a block from her location is accessing the website that has electronic discovery stored? Who's doing that? Who's doing that? Then the judge said, okay, that's about 10 things added to the docket. I'm ready to respond. Kiwi's reaction. She won't sign the document because she's too busy slandering Kendrick on her Instagram page, because I definitely looked at it. Oh, yes. Oh, yes. Oh, yes. She'd be on Instagram just squawking up a big old loud mess with her Chat GPT written captions. Mm-hmm. Mm-hmm. I'm so glad they called her out too. Stop playing in our face. The Law and Order dun dun just played in my head. That's perfect. Marshall Irons. I'm going to use McDonald's Wi-Fi. Completely untraceable. Perfect plan. That's hilarious. Cass, it's almost like these people he's lying on are lawyers or something. It is. Also, I saw somebody say that Necole Key was airlocked out of the chat. She was airlocked out of the chat, but I don't think she is currently blocked on the channel. At some point in time, we'll find out. If you're watching, beloved, go ahead, give it a try. Give it a try. So yesterday after our live, this is from the judge. Judge Code, and it is a multi-order document. Okay? You ready? So you'll get a recap of some of this shit that's been filed that I haven't even talked about. This order addresses 4 recent motions filed by defendants Joe Cooley and Rodney Oliver. It is hereby ordered that Cooley's June 2nd motion is denied. Cooley principally seeks to compel the production of documents. A motion to compel discovery may only be filed if a party fails to produce discovery material within the time permitted by the federal rules of civil procedure, this court's orders, or the party's agreement. Cooley claims that the plaintiff's counsel failed to follow the court's instructions at the April 24 conference to have a discussion with him, but Cooley has not shown that to be true. She said that's not true. You want to talk about plain language from a judge who knows she's dealing with somebody who's not a lawyer. She didn't say hasn't shown cause. She said that's not true. It is further ordered that Rodney Oliver's June 2nd motion to strike documents off of the docket is denied. Oliver seeks to strike an exhibit attached to the plaintiff's February 21 opposition to the defendant's motion to dismiss, which was denied as moot. The plaintiff identified that exhibit as a license agreement and do not reference it in connection with any current motion. The court declines to strike this material, which bears on the issues in this case. The request to strike is also untimely and procedurally improper, including because it does not concern a pleading. It is further ordered that Oliver's June 16 motion to strike multiple things off of the docket is denied. Oliver requests that the court strike all references to the musical composition like that from the amended complaint, discovery, and any argument presented in this case. This material also bears on the issues in this case, and this request to strike is once again untimely and procedurally improper. It is further ordered that Oliver's June 18 motion for a discovery conference is denied. Oliver shall ensure that Necole Key signs the confidentiality agreement by July 1, 2025. Failure to do so may result in an order to show cause. The plaintiffs need not respond further to the defendant's discovery requests until Key signs the confidentiality agreement. The judge told the Barry White Trust, you can ignore these motherfuckers until Necole Key signs the goddamn confidentiality agreement. You ain't got to do shit. The plaintiffs need not respond further to the defendant's discovery requests until Key signs the confidentiality agreement. I said, whoa. So the judge is done too. She said, let me dumb it down for you. I'm ordering her, ordering Necole Key, sign it by this date, or I will call you before me. And you ain't got to listen to another biscuit head thing these people say until you have that confidentiality order in hand. So The confidentiality agreement is not something that gets filed on to the docket. So we won't know unless the parties file something alluding to it has or has not been signed. It's not something that would show up on the docket as being, something we would see otherwise. So we'll just have to wait and see. But this is very clearly like the Barry White Trust has had it, and they have formally asked the judge for a warning, and the judge did not respond to this last letter. She didn't respond to their request for a conference to be scheduled in 2 weeks. She doesn't even allude to it, but she clearly read it because she says, even though she references Rodney O's motion, everything after, it is further ordered that Oliver's June 18 motion for a discovery conference is denied. Everything after that is in reference to the letter from the trust. Oliver shall ensure that Necole Key signs the confidentiality agreement by July 1. Failure to do so may result in an order to show cause. The plaintiffs need not respond further to the defendant's discovery request until Key signs the confidentiality agreement. So the judge did not grant or deny the trust request for a conference in 2 weeks. She didn't directly respond to their letter, but she responded to the main issue that they raised in this document where she is issuing multiple, decisions, which were all denied. And get your shit together. And I'm so glad. I'm so glad. They are bitching and moaning over documentation they already have. They're bitching and moaning over documentation that they already have. And they're trying to say that they don't have access to it. But according to the Barry White Trust, the Ignite feature on document production shows that there were 2 people who accessed the documents. One of the recipients who accessed the file shows an IP address located just a block away from Miss Key's address. Mr. Oliver has not identified the 2 people who accessed the document production. They've been saying forever, we don't have this document, we don't have this document, we don't have this document. First, it was too early for them to say that because it wasn't time for document production. So they were getting ahead of themselves, demanding sanctions, demanding this, that, and the other. Bro, discovery hasn't even started yet. Now they're in discovery, still on the docket, bitching and moaning. We don't have this. They're not producing that. They won't give us this. They won't give us that. And the Barry White Trust is saying first of all, yes, we have. Second of all, production's on a rolling basis. Third of all, we're not giving them confidential shit because Necole Key hasn't signed the confidentiality order from the court. But they're accessing what they say they can't get. Those things are there. Per IP addresses. They're sick of them. They're sick of them. And for them to send a letter to the judge saying, we need you to issue them an actual warning because our clients are incurring additional legal fees because us as the lawyers, we have to respond every time they file inaccurate, faulty, frivolous shit on this docket. This is a straightforward copyright case. And our attorney's fees are growing, ballooning, that our clients have to pay because these biscuit heads are just running rampant on the fucking docket. They can be sanctioned. They can be, held liable to pay attorney's fees, cost time, all of that for certain motions that they file. But they have to be warned by the court first. And this isn't that either. So she didn't really respond to that letter either. It's a warning in another way. It's a tone shift, and you better get your shit together from the judge. And it's Necole Key on notice. It's the judge putting them on notice. I'm not putting up with your bullshit. This is how it goes. This is what you're going to do. She's going to sign that shit. And if she refuses to sign it, you are going to have to come before me and explain, show cause, give a good ass legal reason why she doesn't have to sign it. And they don't have one. So the judge is going to say, no, she has to sign it. And if she says, I'm not going to sign it, she's going to sanction them motherfuckers immediately. Either that, or she will enter a default judgment with prejudice in favor of the Barry White Trust. Can't litigate forward. So since the parties don't want to follow the court's rules, you win. That is within her discretion as the judge. Totally. These people are ridiculous. Yeah, because to give them till July 1 is generous. I mean, it's 7 days, so it's proper. But this is one of those things that needs to be done by the end of the day. Stop fucking around. Check your goddamn ego. I don't know who these people think they are, because their filings are completely unhinged. And yeah, they just be coming up with arbitrary deadlines, do this, do that, all over the place. And it's just like, oh my God. This is embarrassing and pathetic behavior. So, and who knows what's going to happen with their, other lawsuit. They have to actually serve the parties the lawsuit. They have 90 days from the date the court issued the summons to serve everybody, because they're suing everybody, or that case gets kicked. So I don't understand what their rationale is in thinking that they can have any reference to like that stricken from the record in the Barry White Trust lawsuit against them. That is so nonsensical to me. I don't get it at all. It just makes no sense. It makes no sense. But they keep thinking that they've come up with these gotchas. And that's what their filings represent. Like, their filings come in, strong and wrong every single time. And I can tell when I'm reading them that they clearly feel like they've come up with a aha to get rid of that lawsuit against them. And all of it is a fucking joke. I don't know where they're getting these things from other than ChatGPT. It's crazy. It's crazy. And I've been sparing you the madness, but this was good. This was really good. This was a little bit of sense being injected back into the situation. Yeah. And I'm glad that the Barry White Trust is going on the offensive. Because I'm sure, when they're submitting their bill to their clients are like, what the fuck is going on? This this can't happen. Like, we need to reel this in. This isn't a good it's a frivolous waste of the trust resources to be responding to these people who are filing a bunch of nonsensical shit that we have to respond to. That's valid. Totally valid. And I brought it up a long time ago. A long time ago. I talked about this a long time ago. So there are many restrictions that the judge can impose on them to restrict them from improper filings. And she used that word several times: improper, out of order, premature, all of the things. Just because you don't know what the fuck you're doing. And other people got to pay money because of that? Nah, nah. They could easily be faced with a situation where the judge says at a certain point, you're literally being fined their attorney's fees costs. So why do you suspect they suddenly want like that taken back out? Well, because I mean, okay, two things. Number one, it's absolutely foundational to the lawsuit. It's the use of everlasting base in like that brings this all about. So it's foundational to the case. So I'm assuming they think if they can get rid of that, then like no body, no crime kind of thing, right? It's not going anywhere. That is a fucking joke. And the judge said twice, this is foundational, relevant, pertinent, not going anywhere. There's that. And or they are concerned that their new lawsuit is going to get absorbed into the existing lawsuit as counterclaims and whittled down to like one or two things. And so they want to try and keep the like that situation as separate from the everlasting base situation as possible. And the judge is like, no, no. Those are the only two things that I can think of. But as the judge said, it's way too late for that. Procedurally improper all over the place. Untimely. I mean, it's just like, I was like, what? When I started seeing they filed like, I don't even know, so many things that they want taken off the docket. And I'm just like, I don't know where these people get their ideas from. I really don't. Quite literally, other than ChatGPT, I don't know where they get their ideas from. Baby, we don't do all caps here. I'm gonna wait for somebody else to ask that question and just not answer you because you did that. Pull it together. Like, get in line. This friction with the court and this arrogance and do this, do that attitude will get you nowhere. Get you nowhere. You should be focused on getting the people served who need to be served and the entities served who need to be served. And again, there is, a fairly straightforward way to do that, but it's redacted on this channel because I certainly ain't helping no biscuit heads with no bullshit ass lawsuit over like that. I think they've got some valid issues with regards to Epic Records, but beyond that, I think they've lost their fucking mind. I love it. That was so much better. I accept your apology. Rachel Cunty said, I'm a help. I'm a help. Yes, she can dismiss it with prejudice. She can carve it up into several different things. It's the other thing is she can take proactive action, um, as a matter of law. But, while that lawsuit has now officially, it's officially on the docket, summons have officially been issued, they ain't served nobody. They ain't served nobody. And the Barry White Trust said, um, if we get served, we're immediately filing a motion to dismiss that lawsuit because it's psychotic. I'm paraphrasing. But they put that in writing. They haven't been served yet. And I also love that. I also love that because it's righteous pettiness. Because what it says to me is that both the Barry White Trust and the attorneys, because they were suing the attorneys, have said that they are not authorized to accept service of the lawsuit and also will not accept service over email. Yeah, you're gonna have to pay somebody in a state where you're not, so and you're a party, so you can't do it. You're gonna have to pay somebody. Find these people and these entities or the people and the people representing the entities that you're suing and serve them. They're not giving any handouts. Not gonna help you in any way, shape, or form. Distinction of prejudice with or without. So with prejudice, a case dismissed with prejudice means it cannot be refiled. A case dismissed without prejudice means it can be refiled in the future. So when the Jane Doe lawsuit against Jay-Z was voluntarily dismissed by Jane Doe, it was voluntarily dismissed with prejudice, meaning will not be refiled. You're welcome. A great question. So that's it. We'll see where it goes. I th- I think I'm comfortable with this pace of updates on the shenanigans here because it's you want to talk about B-roll. These people are not worth breaking news in any way, shape, or form, unless they get real serious about their shit and start serving people. And that second lawsuit really heats up. I like the judge's strategy of let me just let some shit just stack up on the docket and then knock out a couple things with one good strike. I just love that. I love that. Let all the pins fall at the same time. That's good. That's great. It's like a 4 to 6 week, pattern of updates. I think that's fantastic. I think that's fantastic, and I hope they continue to, demand some accountability and some guardrails and some warnings and, some reining of it in because this just ain't the move. This just ain't the move. This is very much Rick Ross's titties, and we don't like that. Do I have a vague forecast on dismissal with prejudice? I think they have a valid pleading against Epic only. Um, well, no, not Epic only. Epic, don't come for me, okay? Don't come for me. I think they have a valid pleading against Epic. And if they have a valid pleading against Epic, secondarily, they may have a valid pleading against Kendrick, Future, and Metro Boomin. We'll see. That doesn't mean necessarily that I think that any of those artists knowingly did something wrong, because I don't think that that is necessarily the case. So be clear on my distinction there. I'm not saying that they have a valid pleading because Kendrick or Metro Boomin or Future knowingly did something. I think Kendrick is the furthest away from it. I think Future and Metro Boomin are the closest to it, and I have some questions, and I think there's some potential culpability there. Um The everybody else and they mama in the kitchen sink that they trying to throw in, the lawyers, the this, that, and the other, I think they could very successfully get the lawsuit again as it pertains to it being against them, dismissed successfully. Also, I think Kendrick and Future and Metro Boomin and Epic could successfully get the case against them dismissed because they will have lawyers. They will all have their own teams of lawyers. They go share lawyers. They're going to have their own teams of lawyers taking on non-lawyers. So it's unfortunate. It's really unfortunate. I don't remember if it was or if it wasn't, but it doesn't matter if the firm has lengthy experience in the jurisdiction where the case is being argued. There are plenty of law firms that are not in New York that deal with copyright claims through New York. So it's kind of one of those standards. It's not just a feature, he has copyright claim on that song. So legally, he can be sued. This is when we're just talking about technically what the law allows. Not I agree, not I think he should. I've well established what I think about this, okay? So I'm just explaining. I'm not advocating one way or the other. The non-crazy, version of their argument is that Epic violated, their contractual agreement and used Everlasting Base in a way that was outside the bounds of the contract. And based on what they have submitted, I agree. Now they haven't served it, so I haven't seen Epic's response to it, but based on what they have submitted, I agree, and I've said that, and I've written it. I agree. I'd sue they ass too. Well, artists should always be asking if shit should be cleared. I mean, we see with Timbaland just the other day taking somebody else's song, saying, "I thought the artist who sent it to me had complete ownership of it," and then getting a cease and desist from a producer saying, "Excuse me, my shit's in there. What are you doing?" And Timbaland saying, "I didn't even bother to ask the artist who sent it to me. 1, can I run it through AI? And 2, anybody else work on this that I should know about?" Just it's crazy to me, the lack of. But then again, if the label is telling the artist, "It's good. Yes, we have cleared it. We paid them money. We've sent the first installment of payment. Like, it's good." You go into the studio with, "It's good." This is true. It is the law of the land. No typos here. We're all geniuses. We always spell things correctly. Mhm. Yep. I have no evidence of that whatsoever. Period. Period. So, I mean, I think that's one of the benefits of being somewhere small versus being somewhere large, you know? That's the benefit of being somewhere small and having a small, tight team, and, um, being being able to have that ultimate confidence because you know exactly not just how the process works, but maybe observed part of it because 'cause you're all in the same office. So, to that extent, it's, you know, what do you do in that situation if you're the artist and your label tells you that the shit was cleared? And they can even show you some shit that seems to suggest it's cleared, but what is it cleared for? That's the difference. It was not cleared for what was released. That's according to Rodney O and Necole Key, and by my eye, based on what I've seen, because they did put a lot of emails and shit, um, they did attach a lot of stuff to their filing, and I would say there's a problem. That's just my opinion. But it's at the epic for me, it starts at the epic level. If it goes anywhere after that, it goes to Future and Metro. And unfortunately, by association, legally, it does then include Kendrick. That's copyright law. Don't come for me. It's the thing that frustrates me the most about it. It's the thing that frustrates me the most about it because it didn't have to be this way. You know, it didn't have to be this way. Where this case is at right now is that even though discovery is happening, the judge did mandate mediation with a court-selected mediator. Um, which I believe is supposed to happen mid-July. That would be the best, if they could come to an agreement in mediation and end this first lawsuit, that it would be the best thing that Rodney O could ask for. at this point. That's his way out. And this fight with you know, with the lawsuit against them, they're gonna lose that fight. And once you lose, you've lost. Once a jury says, "Nope, I think you owe the Barry White Trust $1,000,000," you owe the Barry White Trust $1,000,000. The best outcome they can hope for is to get into mediation and come to an agreement. But these people have not shown themselves to be reasonable. And I don't think that mediation is gonna be successful. It should be his sole focus. It should be complying with document production and discovery, and focusing on mediation should be his only focus because it's his only out. It is his only off-ramp out of this with minimal damage. If you get to court, to trial, and you lose, they are going to impose maximum damage. Mediation, medium, minimal damage. Trial, maximum damage. Maximum. Let alone all the costs that you're incurring on the way there. But I don't think they have the discipline or the maturity for mediation. I don't think it will be successful, and God bless the mediator who gets chosen for this one, because I think they are completely irrational. So yeah, that's it. That's what's going on. Anything else going on we wanna talk about? AMA, before I go have more macaroni and cheese and bison. Because he gave me a lot. Good God, I opened up those containers yesterday and was like, "God damn, there's a lot of food in here." No complaints. 0 complaints. But AMA, anything else going on out there in the world? Which case are you talking about? Okay. Juice Man Epiphany, peace to you. Nothing like a Zoom meeting to kill the vibe. Damn it. Damn it, damn it. Are you talking about this case? This case went completely off the rails as soon as she jumped on the docket. I couldn't believe it. I mean, you know, people interject themselves into things, and sometimes the most earnest or the craziest will do it twice. They'll try it once and the judge will say, "No, no, you're not needed here." And they'll come back and say, "No, I think I really am needed here." And the judge will say, "No, you're not needed here." And then they usually go away. Necole Key just kept coming. I mean, she just kept putting shit on the docket and the do this attitude from the beginning. And his lawyers withdrew immediately. Said, yeah, so we can't litigate on this case anymore because and the judge was like, word, word, I get it. Bye. And they were like, bye. And that was it. That was it. So, yeah. Anything else going on out there in Psycho Land? Diddy's not testifying. Why would he? Well, why would he? That's the smartest thing he's done so far is not testify. But yeah, over the past couple days, I've touched on, today is the prep day for closing arguments, and they're arguing on paper on the docket over what the final jury instructions are going to be. Sensational media will have you believe that those negotiations are a reflection of the prosecution not believing it made its case, but I don't agree. I think that narrative is coming from Diddy's camp. But yeah, the defense's case was 20 minutes. Just 21 minutes. And then they rested their case, and now today they're preparing their closing arguments. And either Friday or Monday, the jury will get the case. You can't get on the stand. Why would you do that? Why would you do that? Why would you get on the stand and then plead the fifth? Plead the fifth is a universal act. You don't get to answer some questions and not answer others. You plead the fifth to everything. So he can't get up and explain some things and then refuse to, through pleading the fifth, which just looks self-incriminating. The optics of it are terrible. There was no way he was ever getting on the stand for any reason whatsoever. First of all, he has committed crimes. He would be asked about them. Drugs, guns. There's literally nothing he could get on the stand and say that would help him. Nothing. Nothing. His cross-examination would be fucking brutal. No way. Was never going to happen. It's prosecution, defense, prosecution. Closing arguments will start with the prosecution, and then they will go to the defense, and then the prosecution has an opportunity to rebut. And then it goes to the jury. So closing statements start tomorrow, and they have scheduled court for full days tomorrow and Friday. So they don't like to interrupt closing arguments. They like to do one right after the other and not interrupt either. So it's a pretty grueling day for everybody. Yeah, the Commonwealth of Massachusetts is interesting. I don't know what the agreement is here. I mean, it could be different. It could be different, but I I am anticipating that it is prosecution, defense, prosecution. I guess it could be defense, prosecution, but I don't think so. I'm pretty sure it's prosecution, defense, prosecution. So 4 hours, and then, maybe 45 minutes, half hour to 20 to 45 minutes for rebutting whatever the defense said. So, yeah, that could take 2 days. I think they think that they've got So here's the thing, I don't necessarily think that Diddy is going to be found guilty of everything. And I think that Diddy's lawyers' perspectives are that he won't be found guilty, on everything. Um, I do think it's gonna be a verdict that is a mixed bag. I think they're overhyping that because, like, does it matter if he's not convicted of blowing up Kid Cudi's car, but he is convicted of sex trafficking? Do you know what I mean? It's like, you know? But I think a lot of what his team leaks to the media, they do that for Diddy. He not necessarily because he wants that out there, but because he needs to see it out there. He needs to see that out there. Um, so, there are some people who are like, I don't really know if they got it on racketeering. I don't know if they got it on arson. Um, there's some question about one of the kidnapping situations. Did they really get the kidnapping portion of it? And it's like, well, okay, let's say he's found not guilty of those 3 things. If he's found guilty of everything else, he's still facing 15 to 25 years as a starting point. Still very in a very serious situation. So, we'll see. I don't give a shit if he's convicted of blowing up Kid Cudi's car or firebombing Kid Cudi's car. It don't mean nothing to me. So, we'll see. Does it weaken the case? Well, the judge hasn't dismissed any of the charges unless something happened this morning that I missed. So nothing has been dismissed. Um, I think that it's being painted that way because of the discussions that are happening around the language on the jury instruction forms. So, and then there's this. 1988, Jeffy says, even after the verdict, they no doubt are going to try to appeal based on something. Yep. And that will probably, by the way, be a different set of attorneys because appeals are very specific. They may work in tandem with or have overlap with his current team, but appeals is like a specific I mean, Alexandria Shapiro is a top-notch appeals attorney. She's already on, his team. She's one of the best attorneys on his team, frankly. Um, and I've noticed a lot of the stuff that happens on the docket after each day in court, um, are all things that could, in some way, shape, or form, be referenced in an appeal argument later down the line. Um, so they whoever his appeals team is, if he is found guilty and if he does appeal, they will have a robust record of this case and decisions throughout this case to work with and to go through. It's gonna take a long time. Gonna take a long time, but they probably have somebody who's, focused solely on those things. What is appealable? And it has to be technical. So, why does he need to see leaks out there? For his ego, for his morale, for his hopefulness that he can win. He needs another narrative out there, not just here's the salacious things that were heard or said or shown in court today. Well, I mean, that's not up for a judge to decide. So that's why the judge isn't moved, because the judge doesn't get to decide whether or not he gets to appeal or not. That's up to the appeals court. So, you know, this is a judge who knows that this case is going to be appealed. Because of course it is. If he's found guilty of anything, there's going to be an appeal. This judge knows that. And he's doing the best that he can. Did he told him, "I think you're doing a good job," when he told him, "I'm not going to testify." He thanked him and told him, "I think you've been doing an excellent job." And the judge doesn't give a shit about that, just like he doesn't care about Diddy's lawyers alluding to, "Well, this decision is appealable." Yeah, yeah, that's your right. You wanna do that? Go over there and do that. He doesn't give a shit. He's just doing the best he can with what it is that he has in front of him, and I think he's been totally fair. I don't think he's laid down a single, like, controversial decision about anything in this case. Um, so if he files an appeal, he files an appeal. That's his right. No, it doesn't matter that he said this in court. The jury wasn't present. It's not untoward in any way. It's deferential respect. That's it. The same reason he paid to have free Diddy protesters outside the court, despite the fact that has zero effect on the trial. Yeah, optics, morale. No, it doesn't matter at all. What Diddy said in court to the judge does not matter at all. It has absolutely no bearing on an appeal whatsoever because he's not a lawyer. It wouldn't matter if he thought the judge was doing a shitty job. That's not evidence of anything. So, it doesn't matter. It is an irrelevant statement. Yeah, they haven't, so again, the News Nation and TMZ and Fox News are saying that the prosecutors have abandoned multiple allegations against Diddy. And that is not necessarily true. It's an oversimplification. None of the charges have changed or been dropped. What they aren't pursuing is some of the components behind those charges. But insofar, dropping or withdrawing charges, no. Yes, Marshall Irons, all causes for appeal are technical or procedural. Yes. Baby, it's just ego. It's just ego. Ego and control. Ego and control. And we would all want, first of all, we all have an ego, and nobody likes to feel out of control. And you really don't like to feel that way when people are talking shit about you. So, this is an extreme situation, but those are normal human reactions, you know? But TMZ, Fox News, and News Nation, and gossipers always skip the nuance of what is actually happening and jump to, they dropped this charge, they dropped that charge, they dropped this charge. And could that happen? Sure, that could happen. Does that look like that's what happened in the past couple days? No. I've looked at both of I downloaded them and looked at them and brought them up in a live the other day when I told you all. The defense filed their version of a jury form, and the prosecution filed their version of a jury form. What they are saying is that they're going for a simplified form that streamlines some of these charges, and that has been blown up into they're backing away from, or they're dropping this, that, and the other, and I didn't read it that way, or I would have come here and told you. Oh my god, they're dropping these charges. Now, if the judge perceives that they're hedging on dropping charges, they might get called out for it. The other thing that you should know is that pursuant to just about every criminal case out there, um, the Diddy's lawyers did file a motion with the judge to say the government has not made its case in these areas and the court should dismiss these charges. So if the court agrees then the court would just dismiss those charges. And we haven't seen that either, right? So hold your horses. Hold your horses. Let's just wait and see what transpires over the next 24 hours because they will be back in court tomorrow. And before they bring the jury in and start their closing arguments, they are going to be conferencing with the judge on several things. And, you know, folks will be updating live throughout the day of what's happening. Pick a reputable source, not a gossip one. The Associated Press will probably be in the courtroom or in an overflow room, and they have a live blog that goes. So that's one that, you know, you can trust. I think if he's found guilty of some things and not everything, I think that he's looking at, as a first-time offender, he's looking at 5 to 15 years. That's my wild 5 for funsies. If he's convicted of everything, 15 to 30. But we'll see. I know there are mandatory minimums, and I can't remember what those are. So we'll just have to see. That was folly, and it was never gonna happen. He was never going to get a pardon from the governor. That ship sailed when the state had to step up and say when the state attorney's general's office had to step up in an affidavit and say, "Actually, we still have the gun. Actually, yes, we do still have the bullet fragments. Actually, we do still have all this, that, and the other." The state's attorney general's office is an extension of the governor's office. So if the state's attorney general's office is standing behind a conviction and the evidence used, and then so is the governor. It was all optics, never, ever, ever going to result in a pardon because the state of California believes firmly that that motherfucker is guilty and that conviction is righteous. It is laughable. Laughable that people thought they were going to get traction on that. And it's infuriating to drag an innocent woman through all of that bullshit and all of this ongoing harassment for shit that is a fucking pipe dream and never gonna happen. Because he's a little bitch boy crying himself to sleep in his cell every night. Maybe don't shoot women. I don't know, just a thought. So oh, okay, serves. I don't know. There's mandatory minimums. So I don't remember what those are. They're in one of the superseding indictments, and there's like 50 of those. I'm not gonna go back through and figure it out. I don't know. That there's too many variables to go into how much time does somebody actually serve for a crime to try and come up with a number and ask people to take it seriously. All right, gang. Gang, gang. It's good to hang out with you. Glad we got this little update on the pathetic biscuit heads out of the way. It's good to see you. Good to hang out with you. I'm sure we will do it again very soon. I'm gonna go have some delicious lunch. And yeah, take it easy. I know a lot of you are melting today. So, take it as easy as you can. Stay away from other people if they irritate you easily, because child, hot weather and dumb people is a recipe for disaster. So, maintain your peace and you're cool to the best of your ability. And, eat something good, watch something funny. I recently watched Ali Sadiq's My Two Sons and Rugged and genuinely full body laughed. I highly recommend because laughter is really good for you. And these trying times is trying the shit out of us. So, masterful comedy performances, those two stand up specials. And they are on YouTube for free for your viewing pleasure. All right. Y'all have a beautiful, wonderful rest of the day and a wonderful evening. And I will see you soon. Take care. Peace.